My name is John Niles. I am managing shareholder and CEO of the private public interest veterans law firm Carpenter Chartered. I am the attorney who brought the Freund lawsuit. The U.S. Court of Appeals for Veterans Claims has appointed me to serve as its class counsel. This means that for the Veterans Court's proceedings, I represent the class. Many veterans advocates have been posting videos about the Freund versus Collins class action. I'd like to start with a big thank you to them. The Freund lawsuit is very significant for very many people, and every effort to get word out about the case is helpful. That being said, every single video that I have seen posted on Freund requires at least some clarification. I'm posting this video to provide clarity on 4 topics. The first is precisely what problem the Freund lawsuit seeks to address, to correct. The second is for whom Freund seeks to correct that problem. The third topic is where in the litigation, and it is a long process, where in the litigation exactly Freund versus Collins stands today. I've seen a lot of information and unfortunately a lot of misinformation on that point. And then fourth, what to expect in terms of next steps. How can you follow up on Freund and use Freund to your client's advantage? Here I'll be speaking primarily to the representatives of veterans and their loved ones, and in particular, those representatives, the attorneys and non-attorney agents whom VA has accredited to represent veterans and their dependents. So I'll be going through each of these 4 topics momentarily. Please stick with me. The first topic I'll address is precisely what problem Freund seeks to address. To understand that problem, it's going to be helpful to start with an overview of VA's appeals process as it existed before 2017. I mentioned 2017 because in 2017, Congress created a new process for VA. We refer to that new appeals process as the AMA, which is short for the name of the statute through which Congress created it, the Veterans Appeals Modernization and Improvement Act of 2017. So that's the new system, the AMA. We now refer to VA's old system as its legacy appeals system. The distinction is important for Freund because the specific problem that Freund seeks to correct resides solely within VA's legacy appeals system. The fundamental nature of that legacy system is that it was up or out. A veteran who disagreed or other claimant, now refer to veterans, their survivors, their children, anybody who is a claimant or appellant within VA, I'll refer to them collectively as the veteran or the claimant. When they disagreed with VA's decision under the legacy appeal system, they had to appeal to the next higher tribunal and the next higher tribunal and so on for that claim to continue, or else they had to start over in terms of retroactivity and ultimately back pay. There were several layers of appeal available, starting from the bottom of VA's system all the way up through the courts that oversaw VA and still oversee VA now. And the particular problem that Freund seeks to address was at the stage of proceedings that were right before the appeal went to VA's highest tribunal, the Board of Veterans Appeals. So what happened was this: a veteran would file a claim, VA would issue a rating decision denying it, and issue notice of that rating decision. The veteran would receive notice of that decision, and they would say, I'm still not satisfied, I disagree with it. They would file what was called a legacy system notice of disagreement with VA, informing VA that they disagreed with it. VA then would either issue a new rating decision saying, you are right, we should have granted this, we're granting this now, or VA, if they continued to believe that there was no entitlement there, they would issue a document. Generally speaking, there were exceptions to this, I speak in general terms here. They would issue a document called the Statement of the Case. At that point, there was a deadline by which the veteran had to file, if they still disagreed, they would have to file a substantive appeal, is what that document was called. It was the last document the veteran needed to file to secure a review from VA's highest tribunal, again, the Board of Veterans Appeals, or we'll call that the board. The timeline or the deadline for filing that was the later between 1 year after receiving notice of the initial bad decision or decision with which they disagreed, or 60 days following the statement of the case. Generally, it took VA long enough to prepare the statement of the case. This was not an insignificant document. It went through and provided more explanation why VA was denying the benefit. That took review and time. But generally speaking, the statement of the case was issued beyond the 1-year deadline, and so the deadline then became 60 days following the statement of the case. So when I refer to 60 days following the SOC, short for statement of the case, it's not for everybody, but that's generally what was happening for most people under the legacy system. Much to VA's credit, for many years it has been seeking to streamline its procedures, including that it has been trying to move from paper everything to electronic systems as much as it can. And then within those electronic systems, VA has been introducing automation more and more throughout the years. As you're going to see, the Freund lawsuit, the specific problem that it seeks to correct, is an early lesson that when automating a system, you absolutely must keep a human in the loop. One of the electronic databases that VA created to help it organize and track appeals is called the Veterans Appeals Control and Locator System, which we refer to for short as VACLS. And VACLS exists, it was created back in 1990. When a veteran filed a notice of disagreement within this legacy system, VA would put into VACLS, okay, here's the date of the notice of disagreement. When VA then issued its statement of the case, it would be reported in VACLS, the date of that statement of the case. And then when VA received the substantive appeal, VACLS would be updated with that information as well. Here's the date of the substantive appeal, and then a check would be run to see whether the substantive appeal was timely. We're looking at, generally speaking, a 60-day period between the statement of the case coming out and VA needing to receive and process and put and update VACLS to say that you have a substantive appeal that has been received. And I say that VA needed not only to receive but to update VACLS because one of the automated systems that VA created to help for housekeeping purposes, essentially, was that once every month, this automated system or application would run within VACLS that would administratively close every appeal for which VACLS did not report a timely substantive appeal as having been filed. And so as a practical matter, unless VA processed its timely receipt of a substantive appeal before that monthly automated sweeping housekeeping function ran, then that appeal would be administratively closed. And when administratively closing an appeal doesn't mean that the appeal is gone. Legally, it's still there. The veteran has all the rights that they've ever had, but nobody's looking at it from then on. VA is putting it into this warehouse dump, essentially, right? I don't mean to be casting aspersions here. It's just they would be warehousing the claims. No further action would be taken on a closed appeal, being closed for for having no timely substantive appeal reported. This was a problem, became a big problem, because think back to 1990 and the years since. This was a time when many representatives, many organizations helping veterans were using fax machines, facsimile transmissions, to make filings to VA. Meanwhile, VA was having long delays in processing incoming faxes. It could take VA weeks, 35 days or more, to process an incoming fax. And so what was a 60-day deadline, and all of this is happening without notice, by the way, to the veteran or to the representative when VA is not updating VACLS before that sweeping function comes through and closes the appeal. There's no notice going out in these particular cases saying, we don't think you have a timely appeal here or substantive appeal here, we're closing your case. VA would just close it and it'd be sitting there since then, or ever since. And so with 60 days, that's not a whole lot of time for a representative to review this statement of the case, review the facts, see what needs to be done, and speak with the client, and then say, yeah, we want to continue this appeal. Client wants to continue to appeal it, file the substantive appeal. Many substantive appeals were filed day 30, day 40, day 50, day 55, even day 60 following the statement of the case. And very frequently, particularly when VA was having its long delays in processing incoming faxes, VA wasn't putting into its VACLS database before its sweeping function ran to recognize, hey, we've received this timely substantive appeal. VA would eventually process that incoming fax or other transmission of the substantive appeal, and it would put a copy of it into a separate database, the Veterans Benefits Management System, which became later the official copy of the Veterans Claims file with VA. So VA has the document, it's there, but it came in when I say came in, it was processed too late in terms of VA had already closed that appeal and was no longer looking at it. And so you have everybody going on with life. This is at a time when board decisions, after you filed that substantive appeal, you could be waiting 3, 5, 7 years for a decision. And so from the veterans, the representatives' position, you see time go by, no word from the board, no word from the board. That's not necessarily atypical. It's taking the board a long time to be able to consider and decide these appeals. That's part of why we have the AMA today, to help combat those kinds of delays that the up or out system necessitated. VACLS was closing these appeals automatically. Nobody at VA was going in behind VACLS, behind that automated sweeping function to check. And so there was a VA Office of Inspector General report that came out in 2018 that looked at a 3-month period in 2017, and within that time period, very many appeals, and found that double-digit percentage of timely substantive appeals during that time period had been erroneously closed and had been sitting there ever since. Low double digits, 1 in 6, 1 in 7 overall. We have no reason to think that that percentage varied considerably over time. So when I'm describing the problem that Freund seeks to address to folks, it's that, roughly speaking, we think that 1 out of every 6 timely filed substantive appeals that went into VA were erroneously closed, warehoused, and have remained in that status ever since. So you have the board appeal there, disagreement with the denial of the regional office that it made, sitting there, that nobody's acting on, and that's what we're trying to correct. In Freund, we're trying to get these appeals back on track and to the board for decision, or the regional office has an opportunity to pick up the file, say, there's new evidence, maybe we can grant this now, take another look. We are trying to get these claims out of where they're warehoused and moving forward towards decision. In terms of numbers, I'll address that during topic 3, where specifically in the litigation process Freund currently stands. And if you believe that you have a client who is affected by this problem, that'll be step 4 or topic 4 in terms of, hey, what next steps should you be looking to take? Right now, though, I'm going to turn to the topic of whom Freund precisely seeks to help. Is whom, through the Freund versus Collins class action, we're seeking to help. The short answer on that is all claimants with a timely perfected substantive appeal that it looks like VA has erroneously closed and remains closed. More precisely, the U.S. Court of Appeals for Veterans Claims now has certified Freund as a class action, and when the Veterans Court certified the class, it adopted a class definition saying who is in and who is out in terms of this group of similarly situated individuals whose claims either rise together or fall together. And that class definition consists of all claimants with an appeal file in VA's Veterans Appeals Control and Locator System, VACLS, that has been closed at any time between December 12, 1990 and February 6, 2025 for not having a timely substantive appeal and remains closed. Why December 12, 1990? That's when VA began using VACLS, and we have not been able to rule out that this problem of the automated sweeping function erroneously closing timely perfected substantive appeals goes that far back. Why February 6, 2025? As of then, by that time, we're talking about 8 years following the AMA. There's a diminishing body of legacy appeals that are reaching the state of the statement of the case and then substantive appeals. So you have this diminishing body of potentially problematic appeals. Meanwhile, Freund versus Collins was well underway. VA was very aware of this process, and we're convinced that by that time, VA was no longer newly relying on this automated sweeping function exclusively to close or not close the substantive appeals. So in short, as of February 6, 2025, this is no longer, at least on a going forward basis, a problem. So you have this time span then, December 12th, 1990 and February 6, 2025, roughly 35 years where we're hoping to get all of these erroneously closed, erroneously warehoused appeals reactivated and back on track to decision. The third topic about Freund versus Collins that I'll address is where precisely the litigation stands today, June 5th, 2026. This is a lawsuit that began in 2021 before the U.S. Court of Appeals for Veterans Claims, which I'll refer to as the Veterans Court. It has gone up to the U.S. Court of Appeals for the Federal Circuit and is now back down at the Veterans Court. The Veterans Court has certified Freund as a class action. It has appointed me as class counsel, and it is now considering the fairness of a proposed settlement agreement the parties have filed. The parties filed that proposed settlement agreement, which would provide class-wide relief. They filed it in December 2025. Now, it's now June 2026. Why so long? The Veterans Court, first of all, had to certify the class, and now it has a duty to review very carefully the terms of that proposed settlement agreement. The Veterans Court has to make sure that the proposed settlement agreement's terms are fair, adequate, and reasonable, not just for the two named petitioners in this class, but for what look to be the tens of thousands of U.S. military veterans and their loved ones who were within the class definition. The Veterans Court has said that it will be applying a heightened standard when considering the proposed settlement agreement's fairness, considering just how broadly this case reaches. Again, tens of thousands of folks. The court has scheduled a fairness hearing. It had opened up a 30-day period for written objections where any potential class member could write in, having reviewed or through themselves or through their representative, to object to the proposed settlement agreement's terms as being unfair or inadequate or unreasonable in any way. And we did receive objections. The Veterans Court is going to be considering the settlement agreement in the light of those objections and according to its own discretion. The Veterans Court's not going to limit itself at just the objections that happen to roll in. The fairness hearing is going to occur on August 13th, 2026. I will have 30 minutes as class counsel, and the VA's attorney will have 30 minutes to answer the court's questions regarding the proposed settlement agreement. I want to be very clear. I've said proposed. I believe this proposed settlement agreement is very good for the class, or else I would not have agreed to it. The VA believes that this is a good deal as well. Even so, the court has to approve this proposed agreement before any of its terms become effective. If the court were not to approve the settlement agreement, the parties, of course, we could work to try to resolve any concerns that the court has, and if we were unable to do that, then a 3-judge panel of the Veterans Court then would issue a ruling, up or down, on the merits of whether this class action is one that the claimants win on. Are they entitled to relief and having these long warehouse claims reactivated and having them move forward from there. The fourth topic I'll address about the Freund versus Collins class action is what comes next. On August 13th, 2026, the U.S. Court of Appeals for Veterans Claims is going to hold a hearing, and that hearing is very important. The Veterans Court is going to be reviewing the terms of a settlement agreement the parties have proposed to resolve the litigation on behalf of the entire class. Whenever a settlement agreement is proposed on behalf of a class, the U.S. Court of Appeals for Veterans Claims has a duty to review that proposed settlement agreement for whether its terms are fair, adequate, and reasonable. It's not enough that the proposed settlement agreement be good for the particular appellants or petitioners who are representing the class. It's not enough to be good for the attorney who is representing the class, certainly. It has to do well by the class as a whole. Here are these tens of thousands of U.S. military veterans and their loved ones who we believe VA has erroneously closed timely, perfected substantive appeals, warehousing their appeals. What happens after that in Freund depends very much on what the court thinks of the proposed settlement agreement. And certainly, I believe that the proposed settlement agreement's terms are very good for the class. It's the only reason why I would have and did agree to those terms. I think they're very good for the class members. This is a workable, viable solution that gets tens of thousands of people relief as quickly as I believe VA reasonably can do so. But the court is going to have its own opinions. The court opened up a period to receive objections from the general public in terms of potential class members if they believe that any term of that settlement agreement, the proposed settlement agreement, is unfair, inadequate, or unreasonable. It received the objections. Now, when the court considers the proposed settlement agreement's fairness, adequacy, reasonableness, it's not going to confine itself to the particular bases on which folks have written in to object. It will, of course, give some attention to those, but it's also going to be raising its own concerns. And so this is a proposed settlement agreement. There's no guarantee that even though I think it's good, the Veterans Court will think it's good. It might very well reject the proposed settlement agreement. If it were to do so, it could permit the parties to take another stab at this, right? Here is the court's concern, or here are the court's concerns. Are they things that the parties can work through? Maybe yes, maybe no. And if not, then we're in the posture of this is litigation. The parties do have disagreement, and we would need to litigate it before a 3-judge panel. And ultimately, the court would give an up or down in terms of is the certified class entitled to relief. I do think it appropriate for me to outline, at least at a fairly high level, the proposed settlement agreement. And I have been emphasizing proposed because, again, what I'm about to describe is not law. This is not something that has been finalized. It is something that the Veterans Court is considering. During the course of the Freund versus Collins class action, the Secretary, and I say the Secretary of Veterans Affairs, as an attorney who is frequently litigating against, quote unquote, the Secretary, often I'll refer to the Secretary. What I mean is VA more broadly, and the attorneys and other staff members at VA who've been working on this case. They've been running searches to see whether they can identify which veterans and their survivors and other dependents have been affected by this issue. 2 electronic databases are particularly relevant. One is VACLS, one is VBMS. VACLS is the electronic database through which VA has been tracking and monitoring legacy system appeals, and VBMS, the Veterans Benefits Management Database, or System rather, is the electronic database that contains an electronic copy of claims files. All the documents that veterans have sent into VA, all the documents that VA has sent to veterans, all evidence that VA has gone out and collected on veterans' behalf, including service treatment records, post-service treatment records, and the like. And so what we've been trying to do, and what VA has been trying to do, is search through VACLS to see, okay, what is the population of folks whose appeals have been closed for being untimely, supposedly, right? Having no timely substantive appeal recorded within VACLS. And then out of that population, can VA cross-reference the VBMS database to see, well, in VBMS, does it look like there is a document that, if it's a substantive appeal, was filed during this time period for which somebody could be filing a substantive appeal, generally 60 days after the statement of the case. When VA ran those searches, it found 28,258 appeal files for which VACLS reports the appeal file as having been closed for supposedly no timely substantive appeal. And yet when you look into the VBMS database, one of the fields that the VBMS database maintains is a field called document type. And VA receives all sorts of documents. It receives substantive appeals, it receives statements in support of claims, correspondence, third-party correspondence. There's a wide variety. And so one of the values, and actually there are multiple values that this field can take that indicates within VBMS, this is a substantive appeal. And so when VA looked at in VACLS to all the appeal files that are closed, and then cross-referenced that against VBMS, to see, okay, of those closed appeals, it found 28,258 appeal files for which in VBMS there is a document from the time pertinent, the time during which a substantive appeal would have been timely. There's a document in VBMS that VBMS has coded as recognizes as being a substantive appeal. So it sure looks like in those cases, there's a very high chance that those were closed erroneously. They need to be reactivated. Then there's everybody else. And I'll say that in the proposed settlement agreement, if it were approved as is, VA would undertake a manual review of every single one of those 28,258 appeal files to check, is this document, or is there a document within the proper time period that is a substantive appeal? And when yes, VA is then going to write to the claimant is going to write to the claimant's representative, say, here's what we found. We found an erroneously closed appeal file that has been pending for all this time. We are reactivating it, and here is what is coming next. So that's good news for anybody whose appeal filed, if this settlement agreement were approved, whose appeal file VA has closed and warehoused erroneously. And so on the everybody else, there are two groups within the everybody else, and I'll take a step back and explain more broadly that VA is not in a position where it was willing to agree to do a manual review of every single appeal file that has been closed in vehicles on the basis of not having a timely substantive appeal recorded. We're talking about hundreds of thousands of appeal files and many work hours. If VA were to do that, it would not then be able to devote to other activities, including deciding the many claims before it otherwise. What VA did agree to do for this group of folks, anybody who believes that VA erroneously closed an appeal file, is that if this proposed settlement agreement is approved, then VA would undertake for any veteran who wrote into VA to advise it that veteran believes, and I say veteran, it could be the veteran, it could be a substitute claimant or a potential substitute claimant, to advise VA that they believe that there's an erroneously closed appeal file. Every single time VA receives one of those requests, VA will manually review that file. So all that somebody has to do to guarantee that VA will look through the file and reactivate it if it has been erroneously closed is to let VA know, hey, I think there's a problem here. Best way to do that is going to be identify the statement of the case, the date of the pertinent statement of the case, identify the date of the substantive appeal, and then show how there's nothing else happened. The VA has a Form 8 certification appeal that it would typically put into the claims file as a next step. If there's not there, this sure looks suspicious. Representatives should be telling VA that. Within that group of everybody else, and really anybody else can write in as long as they have some basis to believe that VA has erroneously closed a substantive appeal, at least under this proposed settlement agreement. There is a group of 64,599 individuals for whom VA, when searching vehicles and when searching VBMS, VA found that there was the appeal file is closed in vehicles, and in VBMS there was not a substantive appeal within the pertinent time period, but there was a statement in support of claim. And now recall, when you're filing a substantive appeal, it didn't have to be on the VA Form 9 for substantive appeals. It could have been on any document. And for many years, many organizations and many veterans not working with an organization advocate were using this statement in support of claim, VA Form 21-4138, for many purposes, including to notify VA, I continue to disagree with the denial here that I see has been explained in the statement of the case. I would like board review. It was often used. And so there are 64,599 appeal files for which they've been closed. You see that in vehicles, but during the time period that if this were a substantive appeal, right, there's a VA Form 21-4138 sitting there in VBMS. And so for that 64,599 appeal files, we know through experience, and VA knows through its experience, that there are many times when VA will just send out a blank VA Form 21-4138 saying, hey, here's a statement of the claim to the veteran saying, if you have something more to say about your case, use this form, send it back to us. And so there are going to be many claims files where you have blank 21-4138s, the blank statements in support of claim. And VA is going to try to knock those out from manual search and from inviting manual search. But what VA is going to do in terms of, first of all, if it can't reliably rule out just the blank statement in support of claims forms, those appeal files, then for the entirety of the 64,599 folks, and to the extent that it can reliably exclude just the blank statement in support of claim forms, then whatever subset of folks have something written on it, a 21-4138 during the relevant time period, VA is going to write to them and say, hey, here are the facts. We have a statement of the case dated blank. In your claims file, there is a statement in support of claim. that you may want to review to whether it is a substantive appeal. Work with your representative if you have a representative and let us know. If you let us know that you think that we have erroneously closed, for lack of a timely substantive appeal, this appeal file, we will do a manual review, and if it has been erroneously closed, we will reactivate the appeal and we will give you a decision on that case. So that's what's been proposed. There are two groups. There are folks who really look like they have an erroneously closed substantive appeal. When you look at VACOLS, their appeal is closed. You look into VBMS, there is something that VBMS describes as a substantive appeal sitting in there from the time period during which a substantive appeal would have been timely, 28,258 claimants. Then there is everybody else in the world who, if they believe that VA has erroneously closed the appeal, all they have to do is write in to VA and let VA know. There will be a 1-year time period, time limitation for them to do so under the proposed settlement agreement, if that is approved. And then among that, everybody else in the world, VA is going to be reaching out and saying to the 64,599 individuals for whom, hey, it checks most boxes for looking like an erroneously closed substantive appeal. But VBMS isn't saying this is a substantive appeal, it's saying it's something else. And in particular, a statement in support of claim. It's being inviting. We're sending letters to each of those folks and their representatives. Go look at this. If you think this is erroneously closed, let us know. And so, representative to representative, do this. This can have a significant effect on your clients' lives. We historically have found that when it looks like there's an erroneously closed substantive appeal, that oftentimes there is, and these are cases that go back to as far back as 1990. These are benefits that veterans, and all too often now their survivors, are entitled to, have been entitled to, and get these cases back on track, get your decision. I do need to emphasize again, this is a proposed settlement agreement. It is something that we will be defending on August 13th at the Veterans Court's hearing. It will be up to the Veterans Court whether to approve the proposed settlement agreement as fair, adequate, and reasonable. There's additional depth. I've been describing the settlement agreement in terms of details. If you have any questions about the proposed settlement agreement, please do not hesitate to reach out to me. Email is my best contact information, John, John, @carpentercharter.com. That's what to expect next.